friend sitting in on the other side of the table, having political science background, know that a state which is independent and sovereign, it should protect the agreement should be signed between the creator, those who has generated that inventions or idea, and with the state. It balances between rights of creator and public interest. That it's not exclusive right of a creator because somebody other may come out with such an idea. But while writing or contracting those agreements or signing those agreements, the public interests are also taken care of. So it's not that no creator has the sole right. So public interest is also taken. That's why the right, when it is given for a certain period. It's not eternally. Okay. So what are the major intellectual properties? Copyright, of course, as the principal, as your principal sir has said, copyright and related rights, that industrial property that includes patent, industrial design, trademarks, GI, which many people are fighting, geographical indications, GI tag for products, then layout designs, topography, integrated circuits, trade secrets, protection of new plant varieties. These are all major intellectual properties. But remember, at the end of the day, this should be creation of your mind. Okay. Then IP laws, the intellectual property laws in India, it's actually by different departments and ministry. The Copyright Act 1957 of Higher Education, Patent Act 1970, Industrial Policy and Promotion. Department of Industrial Policy and Promotion, the Design Acts of the same department, the Trademark Act of the same department, the Geographical indications of goods by the same department, also the Industrial Policy and Promotion Department, Semiconductor Integrated Circuit Layout and Design Act it's a phenomenon that came recently from 2000 actually by the IT department, protection of plant varieties and farmers' right act. So that's agriculture and cooperation department. So IP laws. Then we'll try to understand all this copyright and related rights, industrial property, under which we'll discuss patent, industrial design, trademarks, geographical. What includes actually this property and what does it? So we'll first see copyright and related other rights. Actually, what is the scope of this property? That's all the original literary, dramatic, musical, and artistic work ideas expressed in a material form. No copyright in ideas. If you have an abstract idea kept in your mind, it cannot be given a copyright. So that idea should have a material form. Let's say you have a particular form of choreography. That choreography or the dance or a particular form of music, that music gets in your mind. If you translate it to the instrument, that can only be the copyright. If you say that it's in my mind, it's not. That has to be translated into material form. So the cinematographic films, also the sound record. So these are the two kinds of rights appeal in copyrights. One, a moral right. The other one is economic. What actually moral right is? The right of the author to protect his or her personality or individuality or identity. That's a moral right. That if it's my brainchild, I have the right to protect my identity and, let's say, my fame or my personality. That is what moral thing. And economic rights, that brings you economic benefit in the form of, as I said, a couple of minutes back, in the form of some return, some profit or some revenue. So it's economic. Two basic things actually which are inherent in this Copyright Act. Copyright. So what is moral right? Right of authorship. So if I have created a literary work, I have created, then I should have the right author. Then integrity and Inevitably I am the author, because the moral right which I have is that I have created this, so I should be the author of that piece, and no, that is so, that is inalienable actually, right. Then economic right, if I have converted an idea into a material thing, then I should have, first thing, I have the moral right or the ethical right to be the author, declare as the sole author of that creation. I should also have the right to convert that creation into economic well-being, so or into my economic benefit in the form of right to reproduce. Like copies, additional ones have produced a book, I should have the right to produce it, reproduce it. Storage in computer memory, because it's my case, a right of distribution or issuing. If I have produced an article, produced a book, I should have the right to distribute it and issue it to others. So digital, including digital distribution, whereas because of late, in this ICT days, it's the digital distribution which is of more importance than physical distribution. Then right of communication to the public. That's my creation. Am I audible? Actually,
Yes, yes. Hello. Hello. A small announcement. I request all the participants sincerely, please do not unmute your microphone and keep your or video in disabled mode. Please. Thank you, sir. Please turn. Hello. Hello. Sir, I think you are in mute mode. Could you please unmute and speak? Hello.
okay, somebody has muted me.
Okay. Yeah, please.
So is the screen visible?
No, sir. You'll have to select the slide. You'll have to select the PPT.
Yes. Okay. Okay. Is it visible now?
Yes, yes, please.
Okay. Okay. So that economic right actually includes adaptation right. That means and translation right. If I want to translate it into different form, or rental right, if you want to give somebody as rent, all these things are clear. Remember, a creation, in addition to the moral or the ethical right, also gives economic right to the creator to generate revenue from his intellectual property or intellectual creation. So ownership of right, it's literally the author, dramatist, music composer, actually photographer, but photography actually are the copyright holder. Then what are the exceptions actually? In case of while copyright is given, what are the exceptions? And in the course of an employment, let's say I am employed at IIT Bhubaneswar, if and actually my basic job is to research, teaching, and publish my work. So in my case, actually, unless and until it's IIT is pleased to give me the right lies with the employer. If somebody is employed with an organization, then the creation and employed for that work. I'm employed to do research in economics. So if I do research in economics, actually IIT will have the copyright. I was also working for WIPO, World Intellectual Property Organization, for 6 months. So whatever we produced, actually we produced a document on the intellectual property, the patent laws and the performance of drugs and pharmaceutical industry in India. So that document actually is the copyright of WIPO. So it's in that. So what are the exceptions actually while giving that? So employment by newspapers, magazine, employer has publishing right, other rights with the author. Photograph, painting, cinema for valuable consideration. Person who pays money for that actually has the right. Similarly, lecture delivered in public. Persons delivery. I was due to this, right? So I now political leaders know deliver lecture. So of course, my lecture also can be considered as public lecture, but it cannot be that public because a code is given by Dr. Vibhuti to me to log in. Similarly, probably a code is given to all members, those who have joined. So it cannot be called as a public lecture, but a public lecture given in a public lecture given will be the person who is delivering the lecture will be the copyright owner. Similarly, government work, government is the copyright owner. Public undertaking work, let's say NALCO or MCL, they do certain work, public undertaking. International organization, when they do some work, people on behalf of those organizations, even if they work, they do not possess that copyright. The organization actually has the copyright. But what are the other work of an apprentice? I don't know actually why the IP law has this. If somebody does apprenticeship with me, then I have the right actually. Say a student does internship with me for 6 months or so, I can actually claim the copyright. This is a little unfair to young minds, but this is how actually in India, if a teacher writes a book, teacher means who is exclusively employed to teach, not to write. But here actually in IIT, I am employed to teach, to do research, and to write, publish paper in economics. But if I write a poem or something like that, there actually I'll have the copyright. But if I am hired for a specific purpose and I do work on that purpose, on that direction, then actually the right lies with the employer, or else it lies with. Let's say somebody in some schools or something where the teachers are hired to teach. If they come out with a book, then the copyright lies with the teacher. The organization actually cannot. Question papers, question setter actually. But if the question setter is paid for that, then the copyright actually goes back to the person who's paid for it. The encyclopedia dictionary editor of that collection. Music under contract by a film producer. The film producer will, though the music is by the composer, but producer actually has the. Then how to secure this copy? Actually, we assign actually to a registration for this copyright, but doesn't necessarily. It's actually see it at times may give you profit, but it's sometimes a voluntary registration. Voluntarily, I register that okay, this is my idea, so this is my copyright. But it can be contestable actually in the court of law. Okay, that's why I said registration does not, as a matter of law, establish that what is registered in fact and in law a copyrightable subject matter. It's not necessarily that if you registered for this, let's say for this stock, you cannot say that it's my copyright. Okay? So it's duration of this copyright. Literary work or something, no, of course we do not have a full lifetime till you are alive. And after that 60 years, probably your successor or your legal heirs will be getting those economic benefits. So that's what actually the duration. As I said, while giving these rights, the public interest or the interest of the common masses or interest of the society is kept in mind. So it cannot be perennial, it cannot be eternal. So as long as you living and beyond that 60 years. All other works, 60 years, but that is for the literary, dramatic, or musical, or artistic work. All of the work actually 60 years from the date of the products of the cases, photograph or cinema or something. Okay. Then what are the related rights? Right, granted by law to communicators or works to the public, like performers, broker existing organizations. For them, actually, rights are also given. So, what is the for the performers? Recording, broadcasting, and communicating to the public of a live performance. The Johnson of transfer of performance right to cinematographic film producers. These are for 50 years, actually, rights. Broadcast reproduction rights given for 25 years. Okay, so this is some idea about what is copyright and how these rights are given and why they are given. They are given to ensure ethical right, that giving identity or maintaining the identity of the author, and at times converting this right into economic benefit. Okay, but a certain period. Remember, when these rights are given, they're given keeping in mind the societal benefit. Then patents. What is patent actually? A patent is an exclusive right granted for an invention who invented something, which is a product or a process. See, prior to 2003, actually, it was only the product patent. That final product is something, let's say, mobile is produced or a computer is produced. The final product is given the patent. But after 2003, processes are also, sorry, it's actually 1998, process are also. That means a product patent is, if I'm given patent of a particular phone product patent, that means I have created that product. So others will be forbidden to create exactly the same. But what happened actually after this product patent was given? It was seen that people started reverse engineering. If a phone is given, then when people purchased it, they started reverse engineering it and produced a similar kind of product with the same process. They followed the same engineering process, engineering pattern, same knowledge, and produced. That's why in 1998, actually, WIPO came out of this World Intellectual Property Organization came out with this idea of process patenting. That the process as well as the product both will be patented. So what is a patent? Patent is given. A patent is an exclusive right granted for an invention, which is product as well as a process that provides a new way of doing something. Remember, a patent can be given only when there is a new way of doing it or offers a new technical solution to a problem. If there's a problem, and the technical solution is given by your product, the product should be given a new solution to the problem. The limited monopoly right granted by the state enables an inventor to prohibit this patent right which is given by a sovereign state. Remember, actually, this contract has to be between a sovereign state and the inventor. Enable an investor to prohibit other person from manufacturing. If I am given the patent, then I can prohibit others to manufacture it, use for selling the patented product or form using patented process. You cannot. Earlier, actually, the process were copied. That's why a process patent was given later on. But when both product and process patent was given, now it restricts others than somebody who's given the patent to produce that product through the same process. If you cannot follow the process and produce a slightly differentiated product and claim that this is your product, that's also is not permissible. Of course, you can do it with my permission or the permission of the person who's given the product. And this patent is given generally for 20 years. And then what can be patented? Can everything be patented? Whatever you produce? No. All inventions actually cannot be patented. Inventions which are novel, that means they're new, and non-obvious, something which is obvious, you say no, it cannot be patented. And it should be new, that should be non-obvious, and it should have utility, industrial application. Utility means it should be able to, the product should be able to satisfy a human desire. What is utility? Utility is the want satisfying or desire satisfying quality of a product. So when you are designing a product or coming out with a new product from your idea and claiming a patent for that, then that product should be non-obvious. It's not an obvious product, and it should be a novel product, and most importantly, it should be creating utility for the society. I said this thing actually in novel, that your invention should not be known to the society or known to the public prior to you invent it, and it should be useful for the society. Practically, it should be helping the society or individuals or the masses to cater to their needs. Then only your your product can be patented. The process, both process as well as the then who gives this patent? Patents are given actually. National patents, international patents also are given. They're valid within the territory and are valid for a given period of time. Foreigners also can apply for patent. Then what is not patented or what cannot be patented? An invention which is frivolous or which claims anything obviously contrary to the well-established natural law. That's actually probably that may be patented, but as of now, no. If actually it's of course I may sound little purist while it say this. When somebody says no, I give more than 100% to this work. What does that mean? When a percentage can be maximum 100%. A machine works beyond 100%. What is that? Performance can be a percentage can be at max 100%. If you claim that your machine works more than 100%, no. So these are all contrary to the established laws or something that is against the gravitation law, which is natural law. This cannot be patented. Of course, at times, probably in future, what will happen, we do not know, but as of now, then these things are not patented. Then whose inventions or machines whose primary or intended use or commercial exploitation of which could be contrary to public order. As I said, anything when a right is given or patent is given, the societal benefit is also looked at. That's why many times actually patents are not given, even if it is new idea, even if it has some utility, even it is non-obvious, but society considers it's different from useful. Society may consider that it's not useful for the society. It's maybe harmful for the society. It has utility. Like so, there is of course friends those who are in those who are economics and sitting here might be knowing actually there is a difference between utility and usefulness. Cigarette has utility, but it doesn't have useful. It's not useful. Okay. Smoking cigarette satisfies the desire of a smoker, but it doesn't actually. It's not useful for the person. So while giving patent, the patent giving agencies or organizations or the sovereign state looks into this aspect, whether the patent will be beneficial to the society or not, to the human or the environment at large. So such kind of things are not patentable or not patented. What it's like gambling machine. You may say that I came out with a new gambling machine, but it doesn't actually help the society. Okay, so you may apply for that, but you have to listen the music of the law of the land. Okay. Similarly, what is not patentable and mere discovery of a scientific principle. As I say, actually, when I said this no copyright thing, I said mere construction of an abstract theory in your mind cannot be patented. That thing needs to be converted into a material product. Then only it can be patented. Like Archimedes principle, superconducting canons. These are not patented. These are all abstract concept which has its usefulness for the society, but they are not materialized. So this cannot be patented. Then inventions, which other things which are not patentable are of a new form of a new substance. These things are not patentable. Uh, Then if you simply mix couple of things and come out with this is my idea, that's also not patent. You know, add 2 3 chemicals and say no, that's not patentable. Actually, it's anybody who can do it through a random process, through some trial and error method, and use in his or her own life, that you mix a detergent with another detergent, you get a better benefit. Then you say that, oh, this is my idea that detergent X, detergent Y are mixed and you get a better result. That's why nobody should mix X and Y. That cannot be, patented. That kind of idea. And then mere arrangement, rearrangement of or duplications of known devices. You would say no, that's, of course, with process patenting, this thing has been reduced significantly. Method of agriculture or horticulture. Remember, the agricultural equipments which you create, that actually can be patented. New agricultural equipments, how weeding machine, the weaving machines, these things actually in India they can be patented. But method of, let's say, if you produce a particular product with a particular process, you say no, this is my process, others cannot follow it. That is not a, okay. So they are not patentable in it. Okay. Plants and animals in whole or part or the form microorganisms, but including seeds, variation, and other species, especially biological process for production of preparation of plants and animals. Examples of okay, clones and new varieties of this cannot be patented. Similarly, a new mathematical method or a business method or an algorithm, let's say you have a business plan, you executed it, you cannot say that other cannot execute such a business. Okay. Then a literary, dramatic, musical, or artistic work, or any other artistic creation, including scenario work and television production. These subjects matter all under the copyright protections. Cannot be patented. Okay. Then non-patent mere presentation of information. If you have some information, simply present that information. That also cannot be patented. The traditional knowledge which is already in the public domain, that's also not patented. However, any value addition, if you use the traditional knowledge to create a value addition, then that can be patented. I can give you an example. Let's say from the tribes, you live in a tribe. From there, you know that a particular plant has a medicinal value. If you bring it to the entire community, the scientific community, you refine that plant and made it usable for the patients who can use it as a medicine, then that can be, patent. So, but see, in India, particularly inventions relating to atomic energies are not patented. Then what is industrial design? So see, if you so go back, actually, I had told you this. I had shown you what are the different. These are the major intellectual property. So it's copyright and relating to the industrial, with industrial property we discuss patent. Then industrial design, trademarks will go one by one. Okay, so I'll go to the once this patent is over. So go to industrial design. What is an industrial design? Means only the feature of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, where in 2-dimensional or 3-dimensional or in both forms, by any industrial process or means, where manual, mechanical, or chemical, separate or combined, which in the finished article appeal to and are judged solely by the design. We understand actually design, but what the intellectual property law interprets design as any features of a shape, configuration, pattern, ornament, or composition of lines or colors, either in 2-dimensional or 3-dimensional form, either made by hand, manually, mechanically, that appeals to the masses, is called a design. Let's have certain designs actually. This consumer products, these are the designs of the consumer products. Then pharmaceutical products, these are the designs. Textile and jewelry, these are the designs. It's a registered proprietor who has created design. Proprietor of the registered design has the exclusive right to apply this design to the article in the class in which the designs are registered. And this is given for 10 years and can be extended for further 5 years. So the design which you create for your product can be you give it may be given the right to use that design for 10 years and you can extend it beyond that for another. What is not registerable design which is not new or original. As I said, any idea, a design is also the reflection of your idea. If it is not new, remember it should be novel, it should be non-obvious, and it should have utility. A design which has been disclosed to the public anywhere in the world prior to the filing. For filing for the design, registration of a particular design, but that design is already known to the society anywhere in the world, you cannot claim that to be your design. A design which is not significant, if it's not different, if it's not differentiated from other known or combination of designs, then it cannot be given the right. You cannot register for that design, or it's scandalous or obscene matter that cannot be. But at times, actually, in India, we give obscene and obscure matter. So, we register actually a design which is contrary to public order or morality. As I said, any kind of right or registration is given to you. Remember, the importance or the uh, uh, usefulness to the society is always looked into. If any kind of registration or right given to somebody will affect the larger interest of the community or the society, then that is not. But why it is required, I'll tell you actually why these rights are required. If rights are not given to ensure somebody's identity or authorship and to ensure to some extent economic benefit, then probably our knowledge will become obsolete. People will not be interested to invention. Of course, we know that if there is a requirement, there is a necessity, there is a requirement for the invention. But we can stimulate it through policies that we will protect your interest, economic interest, as well as moral interest by your laws. Will make the technology doesn't become obsolete. Technique doesn't become obsolete. Product doesn't become obsolete. The new ideas come. People come forward to go and invest in R&D, research and development, and from there come out with new product or new process. Okay, so that's why actually this. If somebody may ask that if societal interest is looked after, then why actually we should give this right or protection, right or protection to the creator or the inventor? Because it will promote invention, it will promote research and development in that area, and that will take forward the society. Okay. These are not registerable articles, calendar, certificates. The list actually, changing the changing the size, changing the layout, flags, emblems, and sign of a country, computer icon parts. So these are things actually cannot be registered. Okay. Then what is trademarks? Trademark is a name of an enterprise or a mark capable of being represented graphically, distinguish the goods or service on one person from all those of others. Logs, Godrej, I'll actually give you the pictures, it's there. Trademarks can be sign, a signature, a word, a picture, a letter, a number, drawing, emblems, all these things actually can be any combination of the above also, the shape of the goods, anything. Okay. Apple has a trademark, Apple, partially cut or partially cut apple, apple is the trademark of apple. So similarly, it's anything, any fruit, anything can be, or a combination of these things can be. And this is registered by the National Trademark Registries and are valid in that country. Registration is made after examination and publication because the trademark registries examine the quality of a trademark and its efficacy, its effect on the society. Then actually it gives, and generally, no, it's given for 10 years, but it can be renewed. Perennially, it can be renewed. Kind of marks on goods, service marks, certification trademarks. These are actually trademarks. Service trademarks include banking, education, finance, insurance. Certificate trademarks, certified by the proprietors as having characters like geographical origin, other things. Actually, collective trademarks. These are the well-known trademarks. Coca-Cola has this. I don't know. Problems actually has this. Godrej has this. G. General Electronics has this. So this, as I feel from the beginning, we said that the registration of trademarks, it can be a picture, it can be a number, it can be facts. So it's a visual form. A trademark could be a audio, sound form of it, or a smell. I don't know, I don't have an example of that. Visual means words, letter, numericals, devices, including drawings and other things, two-dimensional, three-dimensional. So it can also be a trademark, can be an audio. Okay. What is protected in a trademark? Right to use trademark in if you have a trademark, whether it's visual form, or whether it's sound or it's smell, you have the right to use for your product and no sell it for your commercial gain. But state emblems, official hallmarks, emblem of international organizations cannot be used. As say, we wanted to use the World Bank's, emblem as our trademark, a national emblem as my trademark of my company. That's actually is not registered. That's not given. The next thing comes actually GI, geographical indication of a good. Actually, from which geographical location it is supposedly any generated. Okay. So, what is geographical indication? Is an indication which identifies goods as agriculture goods. Actually, we're talking of India, agriculture goods, natural goods, or manufactured goods as originating or manufactured in the territory of a country or a region or locality in that territory where a given quality, reputation, or other characteristics of such goods is essentially attributed to its geographical. Anyways, this is you parents sitting in West Bengal or sitting anywhere in the world because it's a virtual. In Odisha actually and West Bengal, no, they are fighting for this GI tag of Rasgulla. Rasgulla actually. So actually, it's some friends from Odisha they claim that it's from Odisha. Some they claim it from West Bengal. Anyway, it's a mutual understanding at the end. But geographical indication is that identifies goods as the goods from a particular geographical location. Okay, or is explanation clarifies that it needs not be a geographical name. Remember, it need not be a geographical name. It's a basmati rice. Actually, it's not. We don't have a place called basmati from where it's originated. Or rasgulla, it's originated. So it's from a place whose name is rasgulla. It's not that. People in Odisha they say it's originated from Puri. Friends from West Bengal they say it's originated from a, but it's not the name of that particular land. So goods include goods of handicraft or of industry and also goods. So it may include goods with handicraft of particular, let's say, handicraft of Assam, like Assam coffee cap. See it in Odisha also, but it said that it's originated or it has the GI tag of Assam or for that particular industry. You know, Then in India, geographical indications have to be registered. Geographical indications registry examines and publishes the application before registration. Remember, at times actually the registry also gives registration to two different products. Actually, as I said, in Orissa, GI tag is given to Rasgulla, or our friends from West Bengal, it's also GI tag is given to Rasgulla. So they examine the claim, they examine the proofs, and accordingly they give. Registration is valid for 10 years, but can be renewed for perennial. They can say that have, let's say, Pahad Rasgulla, you can write geographical indication on the boot that this is mango from what is that? Mango pickle from
Yeah.
mango pickle from a particular Malda.
Right.
Then trade secrets. Actually, it's another 5 minutes. I'll be through here. So trade secrets. Some inventions data information cannot be protected by any of the available means of IP. So even if you give right, copyright, or patent or whatever, but still it cannot be it cannot protect the trades interest or commercial interest of certain individuals or organizations. I'll say in Coca-Cola, actually in its component say that it uses a particular ingredient which is only known to Coca-Cola. Similarly, Pepsi uses a particular component which is only known to Pepsi. So secrets actually are given. They are given the right to use the secret. So trade secret can be an invention, idea, survey method, manufacturing process, experimental result, chemical formula. That Coca-Cola uses a particular chemical formula, recipe, financial strategy, client database. All these things actually, which they can be kept as which can be kept as a secret by the inventor. One invention is not patentable, because in that case, actually, that invention cannot be patented. That's Coca-Cola comes. So another company also comes. They say we can use the same product. So in that case, actually, since it cannot be patented, secret companies or individuals are allowed to keep the secret of their patent protection is limited to 20 years. When trade secret can be kept beyond that. As you said, no patent is given for 20 years, but trade secret, Coca-Cola has been keeping its trade secret till now. And cost of patent protection is prohibitive when it is difficult to reverse engineer. If it is difficult to reverse engineer, the trade secrets. Then how to get this trade secret? Actually, we may be given the right to have a trade secret, but its onus lies on the individual who has invented it, or the company or the industry which has invented it to get this trade secret. How it can be guarded? By restricting the number of people having access to who are the people those who know what is the secret formula of a particular product, or what is the secret formula of chemical composition which is used for the preparation of Pepsi, is known only to a limited number of people. So restricted. So, signing confidential agreement with the business partner and employees. So they sign the confidence that you maintain this confidential agreement. So we do research also. We write a confidential agreement with our funding agency that okay, we'll keep your data confidentially and everything. So similarly, if we collect information from our friends or from our subjects, we have this confidentiality agreement. Then using protective technique like digital data security tools, which many nowadays actually for this cyber crime and other things, many software companies are using and restricting entry into area where trade secrets. They don't allow to their research lab actually. Coca-Cola or let's say Coca-Cola has its plant anywhere, it sends that composition from its parent company actually from America. It's not allowed to produce here, even though Odisha, when Odisha we have a Coca-Cola plant, that composition actually comes, main composition actually comes from USA. So they're not allowed. Or national legislation provide protection in form of injunction and damages if secrets information is legally acquired. Then what are the interest organizations? Those who protect this all this no intellectual property or intellectual act to promote. As I said, no, when these rights are given, the societal interest is also looked into. But the question may also come that if the societal interest is looked into, why these rights are given? Remember, these rights are given to encourage research and development and to encourage invention and innovations among the people or among the organizations so that it will improve the quality of knowledge. And what are the international organizations actually? Those who protect this thing, the World Intellectual Property WIPO, it is at Geneva and World Trade Organizations. Then how this technology is transferred? Let's say I have created a product, I have the intellectual property right. Then how I can transfer it for the benefit of my benefit and for the benefit of the society through licensing and technology that transfer. That I have the right, I have protected it, I have created it, I have the right. I will give it to somebody. Let's say somebody who produce the same product in West Bengal and sell it there, and give him or her the license. And I'll have a share from his or her data. The product is somebody has taken the license from me to produce it and sell it in West Bengal, and from his or her benefit or profit, he will give a percentage to me. So through licensing, this technology or this knowledge can be transferred from one place to another place for the benefit of the society as well as for the inventor. So it's through license. License is a permission granted by the IP owner. If I am the owner of that intellectual property to another person, I can give the license to somebody to do that. So, and license creates an income source because I have given this, as I said, I'll have a share of from your income. It establishes a legal framework for transfer of technology. As I said, if I have created something which is useful for the society, it should be useful to the society, and also in addition to that, should be helpful for me in increasing my economic benefit. So it creates an amiable or an agreed upon framework, legal agreed upon framework by the inventor and the society and for the community to transfer the knowledge for wider benefit of the society as well as for the benefit of the inventor. It creates market presence for the technology of trademarks. Then licensing condition for IPRs, owners of IP prefer to transfer technology through licensing agreement. Many of them, they would love to do it through transfer licensing process because their interest is protected. All rights or limited rights can be exclusive or non-exclusive or sold, that owner or licensee. Most such agreements provide for royalty payment because if somebody has taken a license from me to produce my product, let's say McDonald's, it gives license to open this and anywhere in the world you open a McDonald's restaurant, some portion of the benefit, some proportion of the profit goes to them. Okay. Then this is actually how licensing will be helpful in converting or transforming the technology from the inventor to the society, and can also be beneficial to the society. I can take a couple of questions or suggestions. I think I'm right in time.
Sir,
Hello.
Thank you.
no, sir. Please continue. Actually, one participant
Pardon?
unmuted. Hello. Yes, sir.
So I'm through. Thank you for your patience hearing, and thank you for inviting me. So you can take. I can take a couple of questions actually.
Okay, sir. Okay. Thank you. Thank you, Professor, for a very informative and relevant deliberation and lecture. Actually, I think, and I'm 100% sure that it has served the purpose, keeping which in mind we just plan to conduct this program today. And thank you for giving us the time in spite of your health issues. It's
Hello.
actually, yes. Shoma Manna, do you want to ask anything or do you want to share anything, please?
Okay, okay, okay. No, no, no.
Well, then mute your
If
microphone, please.
Ratan, if
Ah,
anyone feels any problem in speaking
ah.
English, then you just translate it to Dr. South. Okay.
Sure, 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 sir.
No, আমি বুঝতে পারি বেঙ্গলি, আমি বুঝতে পারি এই দাদা কি এরা আমি বুঝতে
Thank
পারি
you,
তো,
sir. Thank you.
স্যার বল, স্যার
বলতে পারি না,
হ্যালো।
বলতে পারি না, বুঝতে পারি।
Well,
স্যার বলছি আপনার
দাদা আমি আসাম ছিল, শিলচর থেকে I was working in Assam University Silchar for 5 years.
Oh, I see. I see.
And Silchar or that Sylhet is more, if you see the density of population of Bengalis, it's
yes,
the
Yeah,
official language that was Bengali.
মিটিং হয়
yes, sir. So,
সবগুলো
Shoma
তো
ma'am,
হয়েছে
do you want to speak anything? Or do you want to say anything? Otherwise,
আপনারা একটু প্লিজ বেঙ্গলি মে কথা বলতে পারলে ভালো হয়।
okay, okay, sure, sure. আপনি বাংলায় বলুন, no problem. স্যার বুঝতে পারেন।
But you interpret, sir.
Yeah.
It's not audible people, no? Somebody should interpret.
Okay, sure, sure. Yeah, Shoma ma'am বলুন।
পারছি না স্যার ওটা বলছি, ওই যে স্যার যে বলছে না ওটা একটু বাংলাতে কথা বললে ভালো হয়, তাই
Actually,
বুঝতে পারছি না অর্ধেক কথা।
যদি কোথাও কোনো টার্মিনোলজি বা কোনো ম্যাটার বুঝতে অসুবিধা হয়, তাহলে আপনি জিজ্ঞেস করুন, সেটা স্যার একটু এক্সপ্লেন করবেন। কিন্তু এই মুহূর্তে তো আর সেটাকে রিপিট করা সম্ভব নয় ইন বেঙ্গলি। আই থিঙ্ক ইউ ক্যান আন্ডারস্ট্যান্ড আওয়ার প্রবলেম অ্যাজ ওয়েল। ওকে, ওকে, থ্যাংক ইউ। অ্যান্ড
না একটু
যদি
বাংলাতে বললে
Shoma ma'am, I think there is some connectivity problem at your end. So please, you may ask a question later on. We have some important question in the chat box I can see. One is from our Manjusi ma'am, and she has asked, sir, why could a patent be invalidated after it has been granted?
So what is the question, sir?
Why could a patent be invalidated after it has been granted? Means once we are granting or somebody is granting a patent to a particular product, then why after certain period of time it is invalidated, or the patent is not applicable on the product?
As actually I answered it, I had told it during the course of my deliberation, but let me tell you once more. If a patent is given eternally, then the odds to come out with new invention reduces. Because if let's say I am given the patent eternal, then the skill which, or the inherent skill or knowledge which I could have or I have may not be used for the, remember, even if a patent is given to an individual where the individual benefits, society also benefits. But if a patent is given for eternally, or eternally patent is given, then inventors may sit idle. That's what I said, the technology may become obsolete. Okay, I have got the patent, I'll get the royalty throughout my life. You may become obsolete. So there should be some balance. That's why actually it's the patent is given for 20 years.
Okay, thank you, sir. We have one more question, and
Yes.
I read it out. It is from Ranjit Burman. The question is, what are the differences between lease and licensing?
See, licensing is that the inventor gives the permission to somebody during its patenting phase to use the idea or to use the product and gets a benefit. Lease is similar. But basically, the concept which is understood in Indian context, actually, lease, no, uh, is done for, and that's why I started with the definition division. We have property. One is a movable property. Other one is an immovable property. Third one is intellectual property. If you recall my slide here. So lease is largely in Indian case, or for that matter anywhere in the world, is largely related to that immovable property. A building is taken in lease, land is taken in lease, but your brain cannot be taken in lease. Okay, that's why I also said that's no Sanskrit version. No, what is that? Janti vanchoyate noiva chorenapi naniyate dane nono khamjati vidyaratna mahadhana. So that's why I started with three. That's why I started with that, and the division of this property. And lease is largely associated with immovable property. Even a pen or a car cannot be taken on lease. It can be taken on rent or hire. Can be hired. Okay. It cannot be called this. These are all legal terms. Of course, I'm not that good in, because I'm a student of economics, not a student of law. So that's why lease is given, or is a concept, or is a terminology used for immovable property. Rent is something which is for movable property, and licensing is for intellectual property. I should have done that kind of a cycle, but I think you understand that way.
Yes, sir. I hope it has been answered the way it was required. Thank you, sir. Sir, I have actually one personal question. Personal is from my end. I have one question.
I'll
Or
be
it may
glad.
be, or it may be a kind of clarification.
Yes.
So actually, many a time we are working on project and it is funded by different funding agencies.
Yes.
And at the end of the same, we are submitting the same project to the funding agency.
Yes.
Now, after some days, on the basis of the findings that we are getting out of our research work during the project or in the project, we are publishing, or we are publishing some books or articles or journals. So in that case, who will be the copyright holder of that particular product or of the particular publication?
See, if your project is a sponsored project, if it's sponsored by somebody, finance is given. As I said, sponsored project means money is given to you. You have taken money for that. So in my presentation, I have said, if an employer has employed you to work for that organization, then the copyright actually should lie with the employer. So the funding agency should have the copyright. But to encourage research, many funding agencies, particularly government funding agencies, ICSSR, CSR, Department of Science and Technology, UGC, they allow the copyright, they give the copyright to the authors because they want to encourage research. Otherwise, if you've taken a funding agency from a private organization, because of the law, the copyright lies with the private organization.
Yeah. So in that case, suppose if it is funded by ICSSR or ICPR or UGC or DST, whatever it is, so in that case, do we need to take any permission or any consent from the funding agency before we publish the work?
See, that depends on your agreement with them. Depends on, but they encourage, they say that you retain the copyright. You retain the copyright.
Okay.
But so let's say if you publish a book, then the copyright has an economic benefit, because as I said, no, if you publish a book, then the royalty will be given till you are alive, and beyond that also for 60 years. So in that case, actually, the organization realizes that this property should be a national property or a societal property. In that case, copyright may not be bestowed to you. So it depends on the agreement.
Yes, sir. Many a time actually this matter is not clear. Many a time this matter is not clear. So if later on any troubles arises, so just to overcome that,
No, see,
if I want to take a kind
if
of
you
consent,
acknowledge, this is the way
yes,
I have taken these slides from Mr. Jones, and
okay,
one of my research scholar has helped me.
okay,
So I acknowledge. that okay, I have taken these slides from the National Intellectual Property Organization.
Yes.
Even if it is in public domain, I have acknowledged. There is no or nothing wrong in acknowledging that okay, I have taken it from you, or we have taken the funding from them. Acknowledging it actually should be, in Indian cases, should be fine.
Okay. So by acknowledging, we can address all those issues.
Provided the organization, see, of course,
Yes.
at the end of the day, organizations are run by the individuals like us. It depends on the psychology of the individuals, actually. If they
True,
want to
sir.
put you in trouble, they can also put you in trouble. It depends on the
Yes.
agreement.
True, sir. True. Thank you. And yeah, if there is any question from the end of the participant, our faculty members are also there, and our members of IIC of our college are also here. So if there is any question, please, I would request you to unmute your microphone and you can speak it out, please. Well, I think there is no question so
I
far.
think actually it's friends are now actually psychologically on the dining table.
True. To some extent, it is true. So, well,
Yeah.
I'll not take much of your time, sir. I can understand, and thank you very much, sir. Thank you very much for giving us
No,
this
just
time.
say it's just hold on. Actually, somebody has a question.
Yeah, Ranjit Burman.
No, somebody has a question in chat box. Some farmer question. I saw it just.
Yeah, it is from Ranjit Burman. You have not.
Okay.
Yeah.
Ranjit's question is: suppose a farmer working in a field own 3 land. Here, can we told that the following? Can you suppose a farmer working in a field own their land? Here, can we told that the following any rules in a? I didn't get the question. Can you please, sir?
I think Ranjit, can you Ranjit Burman? Yes, bolun.
হ্যাঁ স্যার, সাপোজ একজন ফার্মার তার জমিতে কাজ করছে, তো এখানে কি কোনো আইপিআর রাইট কোনো কি এখানে মানে ফলো হচ্ছে, আমি সেটা জানতে চাইছি।
I think sir বোধহয় বুঝতে পেরেছেন।
Oh, I understood, but I'll answer it in English. But
Okay, sir.
see, I'll
No
answer
problem.
it in, because I don't know the language, actually words for in Bengali. See, intellectual property is for the act of your brain. If somebody works in an immovable property in the land, then that can be as one act. Actually, it can be lease or something. There is no intellectual property there, beta.
ওটা তো স্যার মানে তার নিজের মাথার ভেতর থেকে বের করে তো কাজটা করছে, তো ইন্টেলেকচুয়াল প্রপার্টি মিনস দ্যাট মানে তার ব্রেনকে তো কাজে লাগিয়েছে, তার মেধা সত্যকে তো কাজে লাগিয়ে কাজটা করছে, তো এখানে বলতে পারি যে রাইট এখানে ফলো হচ্ছে।
He has the right over that no product, whatever he has produced. He has the right over that product what he or she has produced. That nobody denies, but that cannot be called as intellectual property. Because let's say the farmer has used the knowledge of climate, has used the knowledge of rainfall, has used the knowledge of, but these knowledge are in the public domain. I've said what is not patentable, which I said that if a knowledge is in the public domain, you cannot claim that to be your knowledge. But whatever produce you have, you can say that is my this is my right. Whatever product you produce, but you cannot say that since I am working in the farm here, you cannot work in the farm there. That's actually the patent gives two kind of right. One is a process, other one is the product. If some farmer says that okay, I follow this particular process of farming, you cannot follow that process. You cannot say that. Okay, so that is not actually IPR thing doesn't come there, beta, because it's not the mental exercise. It's not the brainchild. It's not the outcome of your mental exercise. That's why it cannot. It's the outcome of a physical exercise, and definitely it's the right. The farmer has the right over that land. Farmer has the right over that produce. but doesn't have the right over the method of that production. He cannot say that, okay, you cannot produce this. If he produces in his land, if I am producing in my land, he should let me use my land and produce it. But in case of intellectual property, if I have produced a particular piece of research paper, without my permission, that research paper actually you cannot, or without acknowledging me, you cannot use that research. That's what actually you said.
Okay, sir.
Sir, if you can explain me, am I clear, sir?
Hello. Yeah, Shravanti. Yeah, Shravani Mandal. Do you want to say anything? Hello. No. Okay. Yeah, I think, sir, he has understood because you explained the matter in a very simplest term. So, well, I'll not take much of your time, and I wanted to know, and I wanted to have much more interaction, but I think the time will not permit us. So, hopefully, sir, will get you in our future programs and future deliberation. So, with this expectation, I thank you from the bottom of my heart. And now I would like to request Dr. Dhrubajyoti Pahadi sir, one of the members of our IIC of our college, to please propose the vote of thanks and announce the official conclusion of today's webinar. Sir, are you there? Hello?
Okay, okay.
Yes.
Am I audible, Dr. Sarkar?
Yes, sir. Yes.
First of all, I would like to heartfelt thanks to our Honorable Principal Sir, Dr. Kumar for his continuous support, inspiration, encourage towards new thinking, towards new innovation. On behalf of organizing committee of this webinar, I am very much grateful to our today's speaker, Dr. Dukhabandhu Saul, Assistant Professor of Economics, IIT, Bhubaneswar, for his lecture on identifying intellectual property components at the early stage of innovation. I am sure, sir, our today's participant will immensely benefited rather enriched in knowledge by your nice, lucid and informative lecture on different aspects of IPR, such as nature of intellectual property, different types of rights, patents, industrial design, and so on. And I will again express my thanks to Dr. Shah to spend his valuable time with us in spite of his busy schedule. And I hope that you will remain as both friend and philosopher in our long journey. I also extend my thanks all the participants for their patient sharing and all our faculty members for their help and encouragement. Thank you all again. So today's webinar is can stop over, Ratan?
Yes, sir. Please. Yeah. Thank you, sir. Thank you very